So a lot of landlords want to know about the pros and cons of agreeing to accept Section 8 tenants. In certain states, the landlord simply can't reject a tenant who is showing up with federal funding and has a Section 8 voucher. But in other states, a landlord can outright say, no, I simply don't accept a Section 8 tenant. If you are in a state that has an option one way or the other, I have several things for you to consider about Section 8 housing that maybe you haven't thought of yet. Let's get started. So one thing particular to Section 8 housing is that the housing authority that will issue a voucher and establish that a particular unit is suitable for the program is going to come to the property and conduct inspections. There's a certain baseline that you'll have to meet above and beyond mere habitability. In Texas, for example, a landlord can lease property to tenants in all sorts of conditions as long as the house is habitable. There aren't all sorts of particular things that any, generally speaking, landlord is subject to. And that's true in many states, but where the federal funding of Section 8 is concerned, you're going to be held to a significantly higher standard. And you may find that after an inspection, you're given a laundry list of things that you need to repair in order to make that property eligible. This process could take weeks, it could take months, and even after a tenant is found, you may still be conducting repairs and going through inspections, and so the process may take a little longer than you are used to. But if you are willing to go through this process, especially since all that's happening is your property is being made better, you're fitting that bill, but ultimately the cost of rent that you'll get from the federal government should compensate you for the higher degree of quality that you have in the property that you are leasing out to a Section 8 tenant. But understand that you will go through a process where your house will be inspected, and if it doesn't meet the minimum standard, you're going to have some repairs to do. And so once those repairs are completed and you have eligibility to lease to a Section 8 tenant, you are then allowed to take on a new tenant. Now, we're also asked about the types of tenants that qualify for Section 8. Are they different than other tenants? And the truth is, not really. Section 8 tenants are going to vary across the spectrum, just like all other tenants. Some Section 8 tenants are the best tenants that landlords have ever had. I've heard over and over and over in my Facebook group, Texas Landlords, landlords who are quite content with the Section 8 tenants that they've had and have never ever had problems with them. In other cases, you'll find that just like with all tenants, there are varying degrees of good and bad ones, and there are instances where a Section 8 tenant has had to be evicted. We'll talk more about that process later in today's video, but you can expect, again, that same spectrum of good and bad tenants that exists in the open market. They'll also be present in the Section 8 pool of potential tenants. Now, that being said, there are also varying ways in which Section 8 tenants receive funding from the government. You may have a tenant who receives the entire rent balance paid off by the government and they make a $0 contribution. Whereas in other instances, the government will only pay a portion of the rent. That rent is then split between the tenant and the housing authority to cover the balance. You'll have the same agreement in both cases. Rent established at X, but in the event of a split payment, the housing authority will pay a portion and the tenant will pay a portion. You can expect for the housing authority's payment to come on a regular basis and the tenant's portion to come in accordance with the due date of your lease. If you've learned something today, I would appreciate a thumbs up from you. Any questions or comments, leave those below and I'll get to those as soon as I can. Now, sometimes landlords are disappointed by the amount of rent that their particular rental can gain out of a housing authority contract. Part of the inspection process is a determination of the rent value of that particular home. When that value is assessed, it is essentially locked in stone, and the federal government will not fund anything beyond that mark. If, for example, you have a 3-bedroom, 1-bathroom home, that will likely have a different value than a 3-bedroom, 2-bathroom home. However, there are some times when landlords try to get creative and enter into a side deal with a Section 8 tenant who they know is receiving a significant benefit from the government through the voucher program of Section 8. And that side deal might look like this. We have a landlord whose rental unit was determined at $1,500. But they, in their heart of hearts, feel like the rental unit in the open market could get $1,750. So they make a deal with the tenant and say, look, you're getting a certain amount from the federal government, and that's great, but if you really, really want this place, I'm gonna need a little extra on the side. And so, although we're submitting the following lease with a $1,500 rent to the housing authority, and they'll cover their share, you'll cover yours from that lease, we're going to sign a secondary lease in which you agree to pay $250 more, and the rent will be established at $1,750, even though the housing authority limited rent for this unit at $1,500. And the parties proceed, they find it acceptable, they sign the agreement, and the landlord collects that additional amount. However, if you read carefully, the housing authority's contribution of any amount is subject to their determination of the rent value. The fact that they've determined that your rent is limited to $1,500 means that any attempt on your part to collect more than that is a dishonest gain and likely amounts to a fraud against the government. This is not something that I can encourage, and I certainly dissuade you from entering into an agreement with the housing authority and then a secondary agreement with the tenant. The problems are numerous, but they surface once there's a conflict between the tenant and the landlord, because which lease do you plan to present to the court? And what happens if the tenant has a copy of each lease, one that was sent to the housing authority and the second one that you signed with the tenant, and shows the different leases to the court? How is the court going to respond to you being very creative and finding a way to get extra money? My guess is the court's not going to respond well. If you agree to accept funding from a Section 8 housing voucher, you must agree to the terms of your agreement with the housing authority, which include the fact that they get to set the rent limit. If you are unhappy with that, you don't have to take that tenant if you have the option, as landlords in Texas do, to reject a tenant on that basis. But you certainly don't have the option, again, to make a side deal to accept funds from the federal government on the one hand, and then additional funds from the tenant on the other, in a way that sidesteps your agreement to accept funds at all on a very specific, limited basis. Now, one way that landlords can help themselves tremendously is by sending written notice to their tenants every single time a tenant is in default, whether it's for non-payment, whether it's for late payment, or some non-rent violation. Understand that if you have a tenant that is 100% funded by the federal government, you're never going to have an issue of non-payment, but you might have issues of non-rent lease violations. And if that's the case, the fact that you call them and tell them, or perhaps even if you send them a text, if these are not valid, legitimate means of delivery of notice, in other words, if it's not an acceptable means of notice in the lease itself, then it probably doesn't count. Additionally, if you're sending a notice to your tenant, particularly a notice of legal importance, you should also be sending a notice to the representative with the housing authority. You're always going to have some representative that is in charge of the voucher for that particular tenant. That contact person is the person to whom you should always send an additional copy of a notice of default or a notice of non-payment or a notice to vacate. Any legal notices that you ultimately might share with the court should also be sent to the liaison for the housing authority. If you're not sending these notices, then again, I don't know that you're understanding the agreement that you've signed up for with the housing authority, which requires a notice be sent to them concurrently. By sending notice every time, both to the tenant as well as to the housing representative, you're going to cover yourself in the event that a lawsuit is ever presented. You can demonstrate not only did you send notice to the tenant, but that the housing authority was also notified of each of these incidents. In fact, by notifying the housing authority liaison may contact that tenant and get things straightened out in a way that you potentially cannot. Understand that the housing voucher itself is of great value, and once lost is difficult to get back. This may be something that the representative from the housing authority can explain better to the tenant and ultimately get the tenant to comply with the warning that you sent if you're sending a notice of default, and make sure that your house is well taken care of. Now, way back in March of 2020, the federal government signed the CARES Act. You might remember this. This was during the pandemic and at a time when the federal government was intervening in evictions. And one of the things that the federal government said was that a tenant who was being evicted was entitled to a 30-day notice to vacate. Now, while the majority of the CARES Act has since expired, that provision that requires the 30-day notice to vacate probably hasn't. Now, there's debate as to whether or not it is still in place, but there are many courts that continue to enforce this. And because that's the case, if you're in a jurisdiction that does enforce it or potentially will end up in one, then it's incumbent on you to be aware of the fact that in many instances you will be required to have delivered a 30-day notice to vacate if you're attempting to evict a tenant who is receiving federal funding. By default, your state may allow you to send fewer days, but remember that the CARES Act is still around, and many courts still wholeheartedly have stuck to the fact that that provision, that 30-day notice requirement, is still in place. You'll find that a few courts simply have forgotten about it and simply don't pay that any attention, but many courts still require all landlords who receive federal funding, particularly from Section 8 tenants, that in the event that they're seeking a notice to vacate, that they're seeking possession from their tenant, that a 30-day notice to vacate is absolutely required before any eviction judgment will be signed against a tenant just like this. Now remember that the tenant who stays on rental property with Section 8 funding has received a housing voucher. That voucher is transferable. And if it turns out that a lease is terminating, either because you, the landlord, have come to the end of the lease and will no longer serve as a landlord, you've terminated the lease and you're going to take your property in a different direction, or because the tenant is in default and you've issued proper notice and you've instituted an eviction, or you've simply made a demand and said the lease will end at such and such date due to X, Y, or Z. Understand that a voucher can transfer from your property to another, but it's not instantaneous. That transfer can take 30, 60, 90 days. So that if you're planning to terminate a lease and you're planning to allow a tenant who's remained in good standing, it doesn't help you to surprise them with notice of termination. I would suggest that it's much better for you if you know ahead of time that a lease will not be renewed, and that in your state you can simply terminate a lease in this way, that a lease will not be renewed, or that a lease will not continue on a month-to-month basis, that you are bringing it to a termination date. That again, you notify the housing authority, you notify the liaison who is in charge of your tenant's housing voucher, so that they have an adequate amount of time to find a new place so they can transfer that voucher. Generally speaking, you're going to need about 60 days in order for this to be carried out. Now, sometimes you're going to find yourself in an eviction proceeding and you're going to find that the tenant has done zero to begin this transfer. And even if you've notified the housing authority of your intent to exercise your requirement to terminate the lease and to recover possession from this tenant, you may find that they're going to file an appeal just for the sake of buying additional time. And if they're able to secure that additional time, it's probably going to be so that they can effectively transfer that voucher to another. It may also just be that the process is taking longer than is normal and that an appeal is going to be necessary in that event. But you are entitled to evict a tenant who is in violation of a lease, whether it's from non-payment of their portion of rent or whether it's from some lease violation that has nothing to do with the rent. You do, as long as you've delivered proper notice to the tenant and to the housing authority, you do have the right to terminate a lease and to file for an eviction wherever your state is and whatever your state rules are. Make sure that you reviewed those rules to make sure that you're issuing notice properly and that you are filing properly in the event that you are seeking to terminate the possession of a Section 8 tenant. Yes, landlording can be complicated, and sometimes entering into a program like Section 8 with the housing authority in your local jurisdiction can come with additional complications. If you are unsure about all of the facets of Section 8 housing, this video is a good resource, but there are tons of other videos on this channel that you can watch, and YouTube seems to think this next one right here is absolutely perfect for you. For more learning on everything there is to know about landlording, check out that video and tons of others on this channel. But until next time, landlords, happy leasing.